Yeah.
Cool. Third question. There we go. Right now, here. I have a landlord. She's recently divorced. She has an apartment in her name that was always rented out. Her ex-husband managed this. The lease is in his name. So he was basically the landlord. From the looks of it, I don't know who owner is, but he was acting as a landlord. He has always collected the rent and the deposit. The divorce agreement clearly states that the apartment is hers. So now we're speaking about ownership, and that the rent is to go to her. I mean, that's a court order. He never gave her the deposit. Who's responsible for refunding the deposit? Do the tenants have recourse against the ex-husband at the tribunal, as they have a POP that said the deposit was paid to the ex-husband?
Okay, so it's a fairly straightforward. The question, the details of the question are quite intense, and there's a lot that's been going on with the divorce and the settlement and whatever. But the beautiful thing about law, and when we try to answer these questions from a legal perspective, what we try to do is we try to break it down onto basic principles. Okay, that's how law is in South Africa. We've got basic principles that can be applied to various different circumstances. So something like this, we go back to our basic principles. It seems that the husband is the owner and was had a lease agreement with these particular tenants, was letting out, collecting the rental, and had collected the deposit in the circumstances. Now, as a part of this divorce settlement, this property is going to have to be transferred from the husband to the wife. Okay, that's where it says that the apartment, in terms of the settlement agreement, the apartment is hers. So there is going to have to be a transfer of ownership of that apartment into her name at some point. Okay. Now, once that happens, we have the same old principle that we always use, which is huur, gaat, voor, koop. Okay. So that property, the minute it transfers through to her name, okay, she is now the owner of the property, and she is going to step into the shoes of the landlord in the circumstances. Okay, she now becomes the landlord, and in terms of any rental agreement that would be in place with the husband, say they've got a fixed term agreement that's been signed, she now is replaced and becomes the landlord, and she is expected to uphold the terms in terms of that lease agreement. She is also entitled the fruits of that agreement, i.e., she can receive the rental in the circumstances. Okay.
Sure.
The question here really relates though to the deposit. Okay, that doesn't seem to be a problem to me, because that's just an explanation of how the legal process works. Okay. What's the question here really specifically relates to the deposit in the circumstances, because the deposit has now been paid to the husband. Okay, now the property is transferred, the lease is transferred, and so now the question is what happens. So in law, the basic principle is that the deposit, which was now being held by the old landlord, okay, should in law pass on to the new landlord. Okay, the new landlord obviously is entitled to receive that deposit. They have to hold it in terms of the rental contract between the parties. Okay, so again, every right and responsibility with regards to that deposit, which is set out in the lease agreement, they need to now hold. The interesting thing about this is that there might be a couple of remedies which arise out of law. The first one that sort of picks up to me is, because this is a divorce settlement and it's been agreed that this property is going to transfer from the husband to the wife, we don't have the benefit of the settlement agreements in front of us. But it seems to me that there's going to be some level of, if the husband he's agreed to transfer this property in the lease agreement, and his failure to transfer the deposit as well seems to fall in the face of the settlement agreement as a first point. That I don't think that's going to be the ordinary remedy that most attorneys would go to, because there's a simpler one, which tenants have a claim against the landlord, absolutely. But there does seem to be some level of to what extent has the old landlord now breached his settlement agreement. Okay, so there might be some liability there for the new wife, which is directly against the previous landlord. And then the question was, do the tenants have any recourse against the ex-husband at the tribunal as as they've paid the amount. It would certainly have the ability to approach the tribunal on that on that aspect as well. But because this has been written from there are a couple of different ways to handle the situation. Because this has been written on behalf of the wife, who was the client of the person who's written in, there might actually be some sort of remedy in the divorce proceedings to say that the settlement agreement actually hasn't been complied with in the circumstances, which might, that's a direct remedy instead of the tenants who are a third party who weren't the people writing in approaching the landlord in the circumstance, or the ex-landlord in the circumstance. So honestly, it's illegally, and given the facts, if you looked at the facts, you'd figure out which is the best way to approach the circumstances. But because this person is writing in on behalf of the new landlord, almost invariably, I'd say, let's have a look at the settlement agreements and see if there's been a breach of that settlement agreement, which you could enforce the old landlord to pay over the deposit in the circumstances. I'm not sure if you agree, Bruno.
Yeah, absolutely. Totally agree with you. And it's actually quite interesting because as you're answering the question, I immediately started thinking about, somebody has, is asking from a tenant perspective. Obviously, like, I have a landlord, but obviously coming from the agent, it's a very different conversation, because from the agent, you're going, well, we need to protect our client. So we need to figure out what exactly we're going to tell these tenants. Can they approach the Rental Housing Tribunal and go against the previous landlord? Yes, but I mean, if we're advising them, we'd say, well, go against both, because, hedge your bets. Otherwise, go against the previous one, and he has a story, and obviously with huur, gaat, voor, koop, you're probably looking at a situation where your most direct bet is to go against the current landlord. Yeah.
Sure.
But if you're trying to protect the current landlord from one aspect, from the aspect of this being your client, I then totally agree. Use the settlement agreement to say that he hasn't complied. Obviously, handing over the property, handing over the rent, all rights, obligations. This includes handing over a deposit, because the deposit isn't yours. You're actually holding it in almost a fiduciary capacity. So he's not actually supposed to have pocketed anything. The money's available. It's not his money to do with what he wants. So unless there's some kind of set off somewhere in the agreement where he can argue, but I mean, short of that, sorry, the legislation is quite clear on what you're supposed to do with deposits.
Yeah, and even with the set off, there's difficulties with that, because you're not going to be able to negotiate with money that's not yours. That's supposed to be sitting
exactly.
You can't.
Yeah, exactly.
Even if you try to come to an agreement of, well, I'll replace it, I think you'll have big difficulties with that.
Yeah, no, fair enough. No, absolutely. Yeah.
No.